Welcome to Ducks in a Row, the Estate Planning Guide.
Welcome to Ducks in a Row, the Estate Planning Guide with attorney Erin Nunes, managing partner at Surprenant, Beneski and Nunes, estate planning and elder law. Erin helps Southeastern Massachusetts families plan ahead with confidence, protecting what matters most for their future. I'm Evan Mack, and today we're talking about what happens to bank accounts after someone passes away and what families should understand before they assume everything transfers automatically. Miss Erin, welcome.
Thank you so much. Good morning.
Good morning. Good morning. So, listen, Miss Erin, what happens to someone's bank account immediately after they pass away?
So it's going to depend on how the account is owned. When someone passes, if they are the sole owner on the account, no beneficiary designations, no transfer on death, no payable on death, just their name, full stop. That asset is going to have to go through probate in Massachusetts before it gets to its intended beneficiaries. If there's a designation on it, a payable on death, a beneficiary named, a transfer on death, or a joint owner on the account, then typically that account will transfer via that designation to the beneficiary or to the joint owner on the account.
Okay, so if someone passes away with that joint bank account, what usually happens after that?
So there's two ways you can own accounts jointly. One is a true joint tenancy with right of survivorship. Typically, you would see that between spouses or family members, where the intention is that when one owner passes, the surviving owner gets whatever might be remaining in that account. Then there's something called convenience joint ownership, which is exactly as it sounds. It's meant to be for convenience purposes only. So you want someone to be able to assist you with writing checks or going to the bank on your behalf if you might reach a point in your life where you're not as easily able to do those things. But there is not any intention that that person receive those assets when you pass away. So it's really important how you designate those accounts with the bank, because you might think, oh, I'm a joint owner, that's going to go to me, but it was really labeled as a convenience account, and now that's going to get caught up in the probate process.
So, Aaron, how does naming a beneficiary change what happens to the bank account after someone passes away?
So when someone owns an asset individually, that is subject to probate. And in Massachusetts, probate typically takes about 12 to 18 months before the assets can get to your intended beneficiaries. If you have a beneficiary designation named, that skips over that whole probate process, and it is going to pass almost immediately to the underlying beneficiary. Typically, there's some forms that the bank will have them fill out. They'll provide a death certificate showing that the owner has actually passed away. And then the bank will simply cut a check to the beneficiary, and then it becomes theirs.
Okay, so in what situations would a bank account still have to go through this probate in the state of Massachusetts?
If someone owned the asset individually, or even if it was owned jointly, sometimes what people forget is when one person passes, they've got to update their planning. So it might be husband and wife, for example, or two spouses, for example, who owned a money market account jointly, and one passes away. And the survivor forgets to then either add a beneficiary designation in place or another joint owner. And then when they subsequently pass, that ends up having to go through probate, unfortunately.
So why do families sometimes run into problems when trying to access a loved one's account after they pass on?
Well, because the reality is bills still come due. If they own real estate, property taxes still need to be paid. Homeowners insurance needs to be paid. Any final expenses, funerals, medical bills, things like that. So without immediate access to funds, that becomes difficult to be able to make the payments. If your family is fortunate enough to have some resources to pay them on your behalf, they can certainly be reimbursed once they gain access to those assets. But that's not every family situation. So sometimes there's just not funds available to be able to pay those expenses. And then you're having to deal with, government agencies or creditors who are looking to get paid. So being able to have direct access to those assets makes things much easier for your family after you've passed away.
So, Miss Erin, are there situations where a bank will not let the family members access the money, right away, or maybe during some time?
Yeah, absolutely. If the owner passed away and they were the only one on the account, the bank is not going to let the family gain access to it. We typically see them receive letters saying they need letters of testamentary or letters of authority. Those are terms that are used in the probate process. When someone passes and their assets have to go through probate, the person that they nominate to be the representative of their estate has, certain forms that they need to fill out and processes that they need to complete within the probate court. And once they've done that, the court gives them their authorities. Typically in Massachusetts, those are called your letters of authority. And that's what you need to then present to the bank and other financial institutions to show them that now I'm the person who's in charge of the estate. So now I can, collect these assets and pay bills and things of that nature.
Wow. So, what are some of the most common mistakes people make when setting up these bank accounts as a part of their estate plan?
I would say naming minors as beneficiaries when perhaps it's really not appropriate for the minor to inherit that money. Not updating their beneficiary designations if someone were to pass, or adding another joint owner if someone were to pass, but also having the intention for a particular asset to go among several family members when they've died, but only naming either one as a beneficiary or one as a joint owner, with the intention that, oh, they're going to share this asset. And that might not always be what actually plays out after you've passed away. Sometimes it's because there's animosity among family members. Maybe that person that you named as the joint owner feels like, I did so much, I helped so much, and they intended for this to come to me. When the rest of the family thinks, no, it was mom or dad's wishes that this go amongst all of us. So there can be a lot of conflict if you don't plan appropriately. And if you're not open and honest about what your intentions are. We see so much, I think, unnecessary squabbling after someone passes away just because there's confusion about what the person's wishes were. So the more clear you can be about that, the better it's going to be for your family in the long run.
I'm sure you've seen different things throughout your career. Can you share an example of a situation where a family ran into an unexpected problem with maybe the bank accounts after they passed away?
Yeah, absolutely. There was a situation similar to what I was just explaining, where the daughter was loco. And, she was the power of attorney and she was the healthcare proxy. And undoubtedly, she did a lot of heavy lifting, caregiving and supporting her parents. And she had some siblings who were farther across the country. So obviously, there were geographical limitations in place. And there was a real question about whether daughter had been added to the accounts for convenience purposes, as I mentioned, or was there the intention that she received those assets? And it wasn't clear in the documentation that the bank had. So that was a situation that actually became litigated because there was a discrepancy about what the parents' intentions were, and the brother and sister who were further away sued the nearby sister.
So to kind of put like a nice little bow on this whole thing, why is it so important to understand how your accounts are set up long before your family ever has to deal with this situation?
Well, because I think at the end of the day, you want to have peace of mind that your assets are going to transfer in the way that you intend them to. And the more knowledge you have about that, the better. So make sure that you Regularly check your beneficiary designations. As your family dynamics change, make sure your beneficiary designations keep up with what you want. Has someone passed or has someone been born? And you now want to provide for that individual. You really just want to make sure that what your wishes are at the end of the day is what actually happens. So making sure that from time to time you review those beneficiary designations, that's going to be a critical component to making sure that that does happen.
Wow. It's good stuff, Miss Erin. Thank you so much for your time.
Thank you.
Right. Thanks for listening to Ducks in a Row, the estate planning guide. Visit myfamilyestatePlanning.com to learn more about attorney Erin Nunes and her team. If this episode helped you better understand what happens to bank accounts after a loved one passes away, leave us a comment below and be sure to subscribe. Share this episode with someone who may benefit from hearing it, and we'll see you all next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.